Good afternoon, Madam Deputy Registrar. Kindly call the matter.
Thank you, Judge. Good afternoon. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Guyana, delivery of reserved judgment in CCJ Appeal GYCV number 2 of 2024 between Hardat Singh and Ann Narine. The members of this afternoon's panel are Madam Justice Rajnath Lee, presiding judge.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
Mr. Justice Jamadar.
Good afternoon, everyone.
And Madam Justice Ononiwu.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
May I please the vindicate and attach for the appellant.
Good afternoon, Your Honors. I am Sanjeev Dattadin, and with me is Ms. Jamila Ali, Senior Counsel, and Ms. Mohani Anganu. We appear for Ann Narine, the respondent.
Thank you so very much, Counsel, for being here. Today we have set for the delivery of the judgment in this matter. The judgment has been agreed by all the judges of the panel. Justice Anderson extends his apologies for not being here. This is unavoidable, but he has certainly joined in agreeing to the judgment. Thank you. I'll ask Justice Barrow, who has authored the judgment, to read a summary of the judgment. Over to you, Justice Barrow.
Thank you, Chair. And the usual preparatory observation. This is, in fact, a summary and is not intended to be used as any authoritative statement of the judgment. By a fixed date application, the respondent claimed against the appellant the sum of US dollars 300,000, which the appellant promised to pay in a document claimed to be a promissory note. In the High Court, the Chief Justice decided the document was not a promissory note, but accepted it as evidence of a contract to pay and allowed the respondent to file further evidence and to serve the appellant at his address out of the jurisdiction. Judgment for the respondent was entered at the subsequent hearing, at which there was no appearance or defense by the appellant. The matter was appealed to the full court and the Court of Appeal, which both upheld the judgment. Before this court, the appellant filed 21 grounds of appeal, and on the appeal, the issues of service and the appellant's failure to file a defense arose as major issues. In delivering the judgment of the court, it was held that the appellant erred in failing to apply to set aside the judgment, since a trial had been conducted by the High Court and a final judgment had been entered against him. This required the appellant to engage with Rule 39.07 of the Civil Procedure Rules 2016, which deals with setting aside judgments. By the appellant failing to apply to set aside, he attempted to sidestep the requirement of giving a good reason for his non-appearance when he deliberately did not attend the trial and was seeking to avoid the judgment altogether. The court identified this as an abuse of process. By choosing to appeal rather than applying to set aside, the appellant avoided the filing of evidence on oath and cross-examination as to his non-attendance at trial and the truth of what happened to the documents that unarguably were served at his foreign address. The court examined the interplay between failing to apply to set aside and appealing a judgment, and concluded that while it was possible to appeal without applying to set aside, there would have to be unusual facts for a court to permit that course. Even if an appeal was permitted, an appellant would need to explain their failure to attend the trial and defend the case. The court emphasized the principle that parties cannot achieve by the back door of an appeal that which could not have been achieved or which they failed to achieve by way of an application to set aside a judgment. In dismissing the appeal, the court stated that it was left unconvinced that the appellant had been forthright in his conduct of this matter. Thank you, Chair.
Thank you very much, Justice Barrow. Counsel, just to let you know that we have seen Mr. Dattadin's email that you sent today, Mr. Dattadin, and we have tweaked the order of the court so that the court will grant you standard costs, Mr. Dattadin, to your client.
Thank you very much, Your Honor.
Yes, so both the judgment and the order of the court will reflect that.
Thank you very much.
Thank you. Thank you to everyone. And if there is nothing further, Madam Deputy Registrar, could you kindly close the proceedings?
Thank you, Madam Justice Rajnapli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamila. And thank you, Madam Justice Onowu. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.
Good afternoon.